All right, so as I was saying, every one of us, if we don't make a plan, we have a one-size-fits-all will. That is the state's best guess as to what the average person wants to have happen to their stuff when they die. That's all well and good, but the process you have to follow is terrible. So if you want the process to go smooth, do some prior planning. All right, the keys to an effective estate plan. It requires you to take control of the process. That means you need to go in and you need to meet with an attorney who can put some documents together that meets your needs. It helps to do a little homework. If you're meeting with an attorney, make sure you're asking questions. If they give you recommendations, ask why. Have them explain to you if what the alternative options might be. Have them help you brainstorm a plan. You know, if I just wanted a simple will and I didn't care what my plan is, I don't actually have to draft one because the legislature gave you one, right? You can go down to Walmart and you can buy a will and you just write in the blanks who's getting what, have it signed in front of 2 witnesses in a notary public. But that's probably not going to be a plan that meets most of your needs. You can do some very clever, very logical things if you take control of the process and build a plan that really fits your family. But essentially, the documents that we prepare for you are the legal instructions that your heirs have to follow. And typically that involves some measure of drafting what I like to refer to as a rule book. There's a bunch of different ways or shapes or forms that can be done. But let's go into that in a little more detail. So typically we think of the tools in the toolbox as being a will, or you may have heard of trusts. So let me ask you this. What do I need? If I'm going to take control of my own plan, what do I need? We need a will. We need a trust. What do you guys think? I'm going to require your participation. Who's willing to venture out on a limb? Do I need a will or do I need a trust?
Both.
Think I need both? Okay. Anybody else have any other opinions? Some are saying trust. Anybody saying I need a will? What if I told you, you don't need either? You don't need a will or a trust. So let me give you kind of an example of a typical husband and wife portfolio of assets. We've got most of our stuff owned together, right? We own our homes in joint tenancy. We own our bank accounts jointly. We have our life insurance. We have our annuities. We have our retirement accounts. Those are all payable on death. They use payable on death beneficiary designations. Who knows what POD is? Payable on death. Where do we see those usually? Banks. We typically see that. It's one of the things they'll typically ask us if we want to put a POD on CDs, right? It's commonly where they get placed. And TODs. Where do we see TODs? What's that mean? It's transfer on death. We see that language when we're talking about financial plans, because even though your Edward Jones, your Raymond James brokerage house is really just another bank, they're fancy. So they don't call them PODs, they're TODs. But okay, so let's play this out. This is my pile of things that I've accumulated in my life with my spouse, and I die. So joint tenancy property, when one spouse dies, it's almost easy as just crossing off the name of the first to die, automatically transfers to the survivor. Beneficiary designations. When I die and I present a death certificate to, well, I'm not presenting anything because I'm dead. My family presents proof of my passing to my life insurance company, the holder of my annuities and retirement accounts, and they write a check. POD, TOD, all of my assets transferred. How useful was my will or my trust? I didn't use either of those things. You don't actually need to have any legal documents to transfer your assets. Cool, right? However, I don't like people planning that way, and neither should you, and here's why. When you are choosing people to receive your stuff by automatic transfer after you die on an asset by asset basis, you are guessing or gambling with the good Lord regarding who's dying in what order, right? If I name my spouse as my beneficiary and she dies before me, she ain't getting it. Now what? Same with my kids. Sometimes kids have the audacity to die out of order. No parent should ever have to outlive their children, but it's not our plan. It's the good Lord's plan. So you need a more comprehensive way to plan. Also, if you are simply planning by putting your assets as POD, TOD, transfer on death, you're not accounting for that situation of your disability. There's nothing in that framework that gives somebody control over those assets. And the other thing you need to be aware of, when you simply put joint owners on your stuff or make your assets payable on death, you have to contend with the basic rule of debtor-creditor law, particularly as it relates to joint ownership. So here's a common estate planning strategy that people will come into my office. They'll say, in order to make everything transfer smooth, especially now that my spouse has died before me, I'm going to put my kids on my house with me. I'm going to put my kids on my accounts with me. We're all just going to own everything together so that when I die, it's just theirs. Seems like a very efficient way to transfer assets. However, the basic rule of debtor-creditor law is that whatever my name is on, whatever assets I can legally reach, so can my creditors. That means if you put your kids on your stuff and they have a major creditor event that you can't contemplate, and think the one that affects half of all married couples, divorce, and trust me, a divorcing spouse is a very angry creditor. Your stuff that their name is on is now reachable by their creditors. So that it's not a very effective strategy. There's no exception if the co-owner is a child. So if I put my child's name on my account, my child's creditor will be able to take my stuff.
Is a child under 18?
So that if a child is under 18, you shouldn't put them as joint owner on the assets anyway. Typically the way, that's a big can of worms we're opening up. It's a whole separate conversation, but children generally, their debts and obligations run to their parents. But yeah, I would never put a valuable asset in the name of a child. We would want to use some kind of contraption to avoid liability related issues like a conservatorship or something like that.
How can a contract that creates that creditor situation, how can that be created by a minor?
Okay, so the question was the contract that creates liability, how could that liability attach to my asset if it's my kid's contract?
Right.
Is that what you mean?
Yeah, and this is assuming that, well, go ahead.
Sure, okay. So going back to that basic rule, whatever is mine is reachable by my creditor. So if you put your child's name on your thing as a joint owner of that thing, you've now made that thing theirs too. So if they have a liability event, whether it's caused by medical catastrophe, medical bills drive most bankruptcies in this country. So major medical debt or divorcing spouse, that is financially catastrophic for people to get divorced. And health hath no fury like an angry spouse scorn. In the context of a divorce, it's not beyond an angry ex-spouse to leverage their spouse's parents' property against them to get more and have them take less. So those games get played. The whole notion is you can barely control what happens in your own lives. You don't want to subject your stuff to the stuff you can't control in your kids' lives. That's first basic rule. To answer your question, okay?
Yeah, kind of.
Okay, we can maybe have a follow-up conversation afterwards about that. So if you don't own your assets jointly with someone else, what's another way you can own them? Well, that would be,
One more question.
yes,
I have a banking account, and I get my son on the banking account.
Sure.
Also. Is that what you're talking about?
it depends how that's done. So if I go to the bank and say I want to add my my daughter Harper to my account, there's two ways the banker can do that. The first is by naming my daughter as a joint owner on that account. I would say, don't do that. That's not the right way. I understand the convenience factor of naming a child on the account. The other way is to name your child an authorized signer on the account. So that's under the rules of power of attorney. So what you're doing is your child then can write checks for you. They're doing it as your agent. It doesn't make that account their account. So if they have a major liability event, their creditor cannot seize your account in that structure. So that's the preferable way to do it.
Can you consider continuing as a signatory after the parent has died?
That's the problem with the authorized signer. So with the joint ownership, when I die, my joint owners get it. Then they have the ability to continue to sign checks. The problem is what can happen before death. It's convenient after death. The corollary is while I'm still alive and my child is an authorized signer, they can sign on that account as convenience for me, but the moment of my death, they're frozen out. They cannot access that unless you change the way that account is set up. So we'll get to the better ways to go through that in due course here. So if you don't own your assets jointly with other people, you own them individually. So if I'm the sole owner of my home, I own that individually. If I'm the sole owner of my account, I own that account individually, though I may have an authorized signer who can sign checks for me. So how do individually owned assets transfer to my heirs? Does anybody know the tool in the toolbox that assets transfer to your heirs through after you die? So simple, it's almost a trick question. Individually owned assets transfer in accordance with your last will and testament. That's the tool in the toolbox. Like I said earlier on, as we were getting underway here, if you don't have a will, you get the one-size-fits-all will complements the South Dakota legislature. They have made their best guess, and I'm glad that they did because believe it or not, over 60% of all people die with no plan. So we all have a simple will. There's no bells and whistles to it, and things get really wonky if you have a blended family or you have unique characteristics about your family. But the kicker, your last will and testament equals probate. Equals probate. Your will gets admitted to probate. I cannot tell you the number of times I've had conversations with clients who come in and say, well, I'm not going to have to go through that because I did a will. I made a will, so we don't need any of that court involvement stuff. The court oversees the implementation of your will. So what is the probate process? Show of hands, how many people in here have taken a family member's estate through probate after they passed away? Has anybody here served as, the old word was the executor, the word we use now is personal representative. Who here has gone through probate? There's a couple of them, 3 of them here. So the probate process, what did you think of it? He's laughing.
Very lengthy.
Very lengthy. Yes, probate is okay, it works. It will get you to the finish line. I'll tell you what, if you got a traditional Catholic family where you got 12 kids and they all hate each other, probate is great because there's lots of due process. Any disputes, the court can resolve it under 14 days prior notice. You go into court, tell the judge whatever the problem is. The judge will split the baby. It's great when you have fights, but in most families where we have the, the typical American family of 2, 3, 4, 5 kids, and that's about it. And everybody seems to get along okay, and you play to the strengths of the people who are good mediators, and they're organized and they keep good records. It's probably overkill because they could do that process effectively without involving the courts. But the process works like this. So your will gets delivered to the lawyer of your named executor's choosing. That lawyer will attach that will to the back of an application for probate and file it with the court. The court will review that application and the will and confirm that everything looks correct. And then the court will admit your will into probate, enter an order saying this is in fact your last will and testament. Anybody doesn't agree with that, then you can have a big fight at the front side to sort out whether it's a valid will. But once that will is admitted, the court will then give a permission slip or a hall pass to your named executor. We call that document letters of personal representative or letters testamentary. You guys remember that document that you guys received in that probate estate? That's your permission slip to speak on behalf of the deceased individual. With that document, you can now go down to the bank and gain access to the money that's sitting in the accounts to pay the bills. And trust me, you're going to have bills at that point because the creditor has been waiting about a month to be paid for the funeral home and last week or two in the nursing home, or nobody gets out of life free. So there's always creditors that are shouting to get paid. And then starts the full process of administration that involves publishing notice in the newspaper. That's really frustrating because you have to publish a notice in the newspaper that says, hey creditors, we got a claim against this estate. You got 4 months to bring it or it's forever barred. And then you just have to wait. And that 4-month period has to run its course. And then once you know you got all the bills, you get them squared, you do an inventory showing what was all there and what it was worth. And it's your lifetime scorecard, right? Bear in mind, these are all public records. And then you have to do an accounting that shows where it all goes. And sometimes if everybody's cooperating, you can get heirs to waive some of those requirements and steps. But once you're finally done, you can close it informally or formally. Informally, you have to file a sworn affidavit, and then formally, you have to have a hearing. But that process takes, I've seen it done as quick as 6 months. Usually it takes over a year. How long did it take for you guys? Over a year? Over a year. That's fairly typical. They just drag on. And part of the problem is there's no legal requirement in South Dakota to push them along faster. So they just languish. In fact, late James Getz, Yankton's old city attorney, passed away back in 2013. And his family brought his files into my law office to try to help them wind down his law practice. And he had an estate that was still open and had about $750,000 worth of assets in it. And the guy died back in 1942. Probate was still open. I could give a full lecture to a law school class on what that took to wind that up. But the other thing about probate that drives people nuts is that it's expensive. It is. Whenever you have to take a lawyer with you to the courthouse or do anything at the courthouse, expect to write some large checks. And you cannot do it yourself. Your family cannot do it for you and skip the lawyer, because an estate is not a person. If it was a person, that person would be dead, right? So under South Dakota law, you can represent yourself and that's it. So the estate has to be represented by a lawyer by law. Talk about a racket for lawyers, right? But yeah.
In other words, there's no way to avoid the probate. The family has a trust and a will that it can read to its.
So this is the process you go through if you own your assets individually. So it's everything in this realm is how you own your stuff. How you own your stuff. So we're going to get into that in just a couple minutes, because that is a very effective strategy for avoiding. You're just jumping ahead about a slide or two early here. So, all right. So if you care, go ahead.
Is there a trigger point?
Yes, there is. And for those who die owning less, there is a shortcut, cheater way to get around it. And in fact, they just changed the laws effective July 1st. They made it easier to avoid probate for people who have less. So I don't have a slide for that, but I don't mind throwing out these figures for you. If you own any real estate and the collective value is greater than 50,000, you have to go through probate. But if it's less than 50,000, you can transfer the real estate using an affidavit, so long as the rest of your collective stuff is worth less than 100,000. So you got to do some math to figure out if you can get through it easy or if you have to go through the whole process. But there's not a lot of people, if you have an interest in real estate where your interest is less than $50,000 anymore. I would say there's probably very few houses in Yankton that are less than $50,000. If you don't own real estate, then you can avoid probate if the collective value of everything else is less than 100,000. So real estate less than 50 or remaining assets less than 100. And if you fit within that, you can avoid probate using what we call a small estate affidavit, where you have to swear that you're going to follow the rules, that you're the executor, and there's some built-in delays. You have to let the pile sit there for a month, but there is an easier way to deal with it in that context.
I thought, like, with probate, I realized if my dad died, I'm gonna gather all this paperwork. I'm gonna come to you, Ron, and say, here's all this paperwork. I don't know what to do with all of that stuff.
Yes.
Am I gonna be? In the middle of
Okay, the lawyer has to go between you and the court.
it?
So we just insert ourselves into the money stream, but still the executor's job to wind up mom or dad's affairs. So like I said earlier, nobody gets out of life free, so someone's still going to have to take that checkbook and square all of the debt. Someone's got to file mom and dad's final tax return. Someone's got to, build the records and show everybody that what's left went where it was supposed to go and everybody got their fair share, and you got to show your math. That's the process of administration. There's no way to avoid that, no legal process where you can just dump it off on others, other than to make someone else who's willing to do it, if nobody in the family is, the executor. Whoever you bestow that authority on is the person who has to do all that work. But the lawyer simply has to be the one that shuffles the papers to and fro to get that executor the authority they need. Yes?
Hey, I'm going to be set up as an executor. What if I die tomorrow? Is there like another person?
So my hope is the will that you are dealing with here has a roster, and there's more names in the position. So if you're gone, there's a then, and then, so you have a way to keep that role filled. But if the person that's named has predeceased, there is a pecking order by law that identifies who acts based on order of relationship to the deceased individual. So a spouse gets dibs, then the kids, and then other members of the family. But it's more complicated if you don't have everybody in agreement, because if you don't have a name listed as a backup, and the next in line would be a child, and you have 6 kids and they don't get along with each other, the one that steps up to the plate is going to have a hard time getting written consents from the other kids. So then you have to have a hearing, and you go before the judge, and you all get to make your best pitch for a job nobody wants, and then the judge decides and bestows that authority on somebody. So it can be a lot messier, and as a result, more expensive. Anytime you have to take extra steps to the courthouse to have the judge decide something, that jacks up the cost another $1,000. So the more you can get down in writing with backups to backups, the more smooth and hopefully cheaper the process will be. But it is possible to avoid the probate process entirely if your assets exceed the $50,000 worth of real estate or $100,000 worth of everything else, if you care. One thing my father pointed out to me is why do I care if you guys have to take my estate through probate when I'm dead? Because guess what? I'm dead and my son's a lawyer, so he can figure it out. So it took me years of browbeating him till he finally understood that not even lawyers enjoy the probate process. It's avoidable, so let's plan to avoid it. Okay, so it looks like I had this slide out of order here. Okay, so how do I avoid probate without planning for destiny just by putting payable on death beneficiaries on all of my stuff, or joint owners on all of my stuff? The best tool we have in the toolbox right now is the revocable living trust. It is a remarkably simple tool. So I would like one of you who feels comfortable enough to throw out an explanation of what a trust is. I have lots of folks who say, I kind of know what it is, but can you explain it to me? Who here feels like they could, in a sentence or two, explain what a trust is? This is always a fun experiment. If I get one or two that step up. Anybody want to give it a try? Nobody feels brave. Okay. I'm going to give you a visual image. Whenever I say the word trust, or anybody says the word trust from here until the end of your life, I want you to think of this. All it is a wagon. It's a legal entity that exists for no other purpose but to hold stuff. It's governed by a rule book. So your basic red wagon is intended for purposes of avoiding probate. It's designed to make the process cheap and efficient for you after you die. So it's governed by this book. So I'm betting, if for those of you that have wills in here, the length of your wills is maybe 3 to 5 pages tops. Does anybody have a will here longer than that? I don't see any hands. So those of you who have wills, that's fairly typical, right? That's because the process by which your will is carried into effect is a book this thick. It's called the Uniform Probate Code. And it covers every conceivable thing that you can think of that might happen with a person's stuff or their estate after they die. So if you're going to make a process that avoids probate, you have to make your own process. You have to make your own book. So your will might be only 3 to 5 pages long, but if you're going to make a trust, you're now going to have something that might look as long, somewhere between 20 and 60 pages. So the first thing I'd tell you is, if you're planning and you're one of those guys that says, if it doesn't fit on one sheet of paper, I'm not interested, you're either going to have to set that aside or just commit to the fact that you're going to have probate, because you can't do it in just a couple pages. There's no way. Put a little faith and trust in your lawyer that all that white paper, you don't necessarily have to understand what every paragraph means. It's kind of like trying to read your mortgage. But it's good enough to understand conceptually, and then know the will that's built into it and make sure you're comfortable with that. It has a lot of meat in it that only lawyers care about. Okay, but that's the first step. You're going to have a rule book. When we think of the wagon as an entity, other types of entities under the law that you are probably aware of would be corporations, LLCs. They are fictional people that can own stuff. And as a result, entities need to have legal officers who speak for them. So in corporations, we have president, secretary, treasurer, vice presidents. These are people who speak for the entity. LLCs have members or managers. Well, the entity of the trust uses something called a trustee. So when you hear the phrase trustee, that's simply the person who's dragging the wagon around. So in your trust, if the purpose of the trust is simply to avoid the probate process after you're dead, you can be your own trustee. You get to pull your own wagon. So the way it would work is you'd create a rule book that says, while I'm alive, I get to drag my own wagon wherever I go. I'm in charge of the wagon. I get to decide who plays with my toys that I put in my wagon because they're mine. That makes you what we call the beneficiary. Another legal term of art, meaning the person for whose benefit the trust was made. If the purpose of the trust is to avoid probate, you are both the trustee and the beneficiary. That means there's no restrictions on what you can do with your stuff. If you want to take your trust down to Vegas, put everything you own on the roulette table, you can do that because it's still yours. I don't think that's a very wise financial decision, but there's no restrictions. Then I'm the fool. All right. When you die, the rules change. The rules simply say, until my death, I pull this wagon wherever I go, I'm in charge. But the moment I die, the handle drops to the ground, and the trust agreement says, all right, Ross is dead. Now, he's named eldest child Harper to step in, and Harper is the new trustee, and she has to follow this new set of instructions, which is effectively the obligation to pay my final bills and expenses, because nobody gets out of life free. And then when my bills and expenses are paid, as the trustee, it's her job to divide up my stuff in accordance with the instructions that I leave behind. It functions just like the administration of a will, but the lawyer doesn't have to drag anything through the courts. Now, having said that, in the occasional family where the kids are at each other's throats, if they're gonna fight, the best part about dealing with the trust is you can just bring individual fights to the judge rather than overseeing the entire estate process. Now, I have seen situations where there's so much distrust in the family, kids do not get along with each other, and every stage is a fight. So one of the options that you have as a trust when you're administering it is you can bring the trust to the court and ask the judge to supervise the administration. So effectively, what you're doing is you're taking a trust and turning it into a probate, but that is not the default unless everybody wants to do that. So in a typical family where the kids get along, you don't start at the courthouse, but it's still available if you need it. So it is still the more flexible approach. But that is the best part. It avoids probate. And now I have had people ask me, why does a trust avoid probate when your will doesn't? What is the legal mechanism that allows this to not go through court? Well, think of it this way. Whatever I own in my individual name, when I die, picture I have it all on my back, everything I got, just a big bundle of stuff. When I die, it falls to the floor. And the law says, oh, that fell off his back. Nobody touch it. Bring me a will. So someone's got to bring the will to the judge, and the judge has to oversee it. Now, when you're using a trust, remember we have created this entity that owns stuff. The entity is incapable of dying. It can't die because it's this magical thing. The law said, behold, there is a thing called a trust, and you can put stuff in it. Since it can't die, there is nothing that triggers probate because probate only governs the assets of deceased individuals. So when you utilize a trust, nothing goes through probate because it all comes down to how your stuff is owned at the time of your death. Any questions about that mechanically?
What's irrevocable?
Ooh, I love that question, and we're getting there. So when you're setting up a trust, folks are very much concerned about their ability to change the plan once they've set it. And we often conflate that with the notion of revocability versus irrevocability, but a well-drafted trust will always allow you to change the rules, particularly your will that's built in. You're never going to be, if it's drafted right, you're never going to be in a position where if one of your kids becomes just rotten rapscallion scoundrels, that you can't write them out. You always maintain control over your stuff. So there's two types of trusts in the big picture. So you brought up revocable versus irrevocable when you asked your question, but there's actually a more fundamental question or fundamental division first. The first kind of trust I want to talk to you about is what we refer to as a testamentary trust. Who here has ever heard of a testamentary trust? What is a testamentary trust? Do you have the ability to explain that, you think?
Well, I just know that
dad set one up for my brother.
Ah, good.
And then I'm trustee. of
Right.
that.
So you're a very good example because that was in the context of probate, right? And in probate, your dad's last will and testament had to be tendered to the court, correct? All right. So a testamentary trust is a trust, a wagon, that is built into somebody's will. And although you don't get to avoid probate, what you can do with it is create a framework by which somebody inherits their stuff, their share of the estate, with some measure of strings attached, some training wheels, if you will. My pastor was fond of saying, every child has different gifts and graces. And sometimes that means the gifts of one do not extend into the realm of money management. It seems like I have occasional families where we have the spendthrift child. You give them $5 and they somehow manage to spend $6 and they're back with their hand out asking for more. Or children that have addiction disorders or things like, pick your vice. Gambling addictions can be financially devastating. You never want to give someone with a gambling addiction any inheritance outright. So when you structure your plan, whether it's through a trust or even a will, you can build a trust in to make sure that the inheritance is received in a way where it's likely to last. Usually it involves putting somebody else in as gatekeeper, a trustee, if you will, to manage the share of a beneficiary and function as kind of the gatekeeper. Is it a good reason to write a check or not? Sure, here's money for college. No, you don't need a new boat, that kind of thing. And that's in the classification of a testamentary trust. It's created through your last will and testament, or at least upon your death. The second type of trust is the living trust. That's the trust that I've been explaining to you, the little red wagon that we pull around with us wherever we go. Living trust can come in two basic forms, revocable and irrevocable. Now, I want you to think of the revocable trust, its core purpose is to avoid probate. So from here on out, we're going to try not to use the word revocable, because revocable and irrevocable get conflated and confused, and I've had arguments with people because they didn't quite understand the lingo and we were talking past each other. So when we say revocable trust, I want you in your mind to think probate avoidance trust. That's the probate avoidance trust. In an irrevocable trust, there's some aspect of it that you have given up the right to do in a way that you cannot change it. The rest of your life, you're stuck with it, okay? And in doing so, by giving up some right, you get some kind of legal benefit back again. You get a, I've heard this kind of analogized to the rabbit's foot or the bear's paw, that you can make a wish on it, but you better phrase your wish very carefully because you lose something that hurts really bad in order to get your wish. In the irrevocable trust, you can gain some pretty cool things from it, but it comes at a cost. So the most common type of irrevocable trust that I see in my practice is usually an irrevocable trust designed to protect some amount of core assets from, say, a nursing home or another unforeseen future liability. I actually have a lot of professionals who like them. If you're a doctor, accountant, lawyer, they make good tools in case you do something. Major mistakes can be very costly in your line of work, but the creditor we're always constantly worried about is that nursing home at the end of the rainbow, because it's outrageously expensive. A typical average nursing home costs somewhere between $6,000 and $8,000. We're lucky here that we've got a wonderful facility on the edge of town. Their fees are as high as $11,000 a month. So it sucks the money right out of your out of your estate. That was the Freudian slip because I was going to say assets. Sorry, it sucked the money right out of your wallet. The trust, the asset protection irrevocable trust is effective for shielding the core of your apple, okay? It can't hold everything though. So if you're going to use it, you have to choose what assets you want to guarantee as inheritance for your kids, with the understanding that you're putting it in a lockbox. Because the compromises you have to live with to make that work make it not well suited to hold everything else. First of all, you can't be your own trustee. It's the first thing you got to give up, and that's a big one. You can't pull your own wagon. That spooks a lot of people. If I got to name my kids as the people who pull my wagon, what's my assurance that they're going to do what I tell them to? Now, of course, good drafting would allow you to fire the child that isn't cooperating and pick somebody else, even if it's your next door neighbor. But you cannot be your own trustee. Second of all, that trust needs to restrict your access to those assets in a legally meaningful way. That means under current law, you can design that trust as long as you live on the north side of the river to give you direct access to income generated from your trust. So if you've got land or a rental property, or you got a brokerage account, you want to preserve those assets, whatever they make for you, whether it's rental income or dividend income on mutual funds or stocks, you can draw that out and you can live off of it. But the principal, the raw value of what you put in that trust, it's got to stay in that trust. So those assets can change, but they never come out of the wagon. So for instance, I could put my home in that trust. My trustee, at my direction, could sell my home. I've converted that now in the wagon from my home into cash. And then my trustee could use that cash and buy me another home. That's okay. Can use that cash and buy me a condo someplace warm and sunny, and now I can snowbird. That's great. But I can never take that cash out, take that bucket list vacation around the world that I've been wanting to take. Because once it's in that trust, it has to stay in that trust. So that's a pretty big compromise. And that also is why you cannot put everything into that trust. There's no trust tool that can shield all of your stuff, because the net effect would be you're impoverishing yourself just so your kids can enjoy it after you die. That's the tail wagging the dog. I never want to see my clients do that by overfunding an asset protection trust. And these rules that apply while you're alive, you can never change. You set them and they're locked. So you can never get more out of that trust than just the income that it generates.
Different states have different rules.
Yes, remember when I said the people who live on this side of the river get the income? If you live on the Nebraska side of the river, you can't even get the income that it generates. It's a lockbox. Now, clever lawyering, I can figure out a way around that, but it's harder, it's messier. Usually involves adding an LLC. Go ahead.
You do two trusts then?
Yes, yes. I wasn't even gonna bring that up here anyway, but that's the best plan if you care. So if you have a strong desire to shield core assets, maybe from the nursing home or another unforeseen future creditor, you choose the assets you want to protect, like the family farm or my home or whatever. You would move those into the irrevocable trust, and then you would have the probate avoidance trust hold everything else. And you would literally put everything else you own into the probate avoidance trust then. You just have two wagons. You can pull two right along with you. Well, really, it's your kids pulling the one and you're pulling the other. So yeah, that is the most flexible way to do both asset protection and probate avoidance. Some folks will just do the asset protection and then they'll gamble. They'll try to put all of their other assets into some form where it will automatically transfer upon death by either putting their kids on as joint owners or making payable on death beneficiaries, even though I say that's a really bad idea. You know, they're willing to do it with their eyes wide open, so be it. But in my opinion, if a client cares very deeply about asset protection and probate avoidance, I strongly encourage them and regularly do create a two-trust plan to accomplish both objectives. Does that make sense? Because both trusts avoid probate, but you can't put everything in the asset protection trust, so you need the other one to hold the rest.
And both of these are irrevocable.
The probate avoidance trust is revocable. The asset protection trust is irrevocable. Now, having said that, a couple slides ago, I indicated to you guys that a good plan still allows you to change the rules. The irrevocable asset protection trust plan does still allow you the flexibility to change your will. You can still change who gets your stuff and how, who's in charge. You have a pretty good measure of flexibility over that trust. What you are irrevocably giving up in that irrevocable trust is the right to only receive the income or the use of those assets without consuming it if you live on this side of the river. And in Nebraska, all you can do is use the assets with no right to the income that it generates. So for instance, my home. I can live in my home without consuming it. I'm using the asset, but I don't get anything else. Does that make sense? Unless you're willing to allow your affairs to get rather complicated. Through clever lawyering, we can, like I said, we can end around some of those rules.
I have a question.
Yes.
If you do that asset protection and you have a trustee, can that trustee just do whatever they want with their stuff? Are there rules? Is there a rule book?
There's a framework around that because they're managing your stuff, right? So we lock it down pretty tight. So one of the ways we do that, and to give you as much of a measure of control over your stuff as possible, we give you a hat to wear. You're no longer the trustee, but we make you what's called the trust advisor. It's another legally recognized officer position. Corporations have, president, vice president, secretary, treasurer. Trusts can have trustee, trust advisor, trust protector, and they're different. They do different things. Well, in this particular context, we would make you the trust advisor of your own trust, which gives you the authority to direct the management of the assets that are stuck in that way. So you get to, maybe the better analogy is you're like a stagecoach driver. Instead of pulling a wagon behind you, you're sitting up on the stagecoach, whipping the horse trustee, doing what you tell them to do. And if they don't cooperate, you retain the power to fire them and find somebody who's going to be more cooperative. So you do have pretty good control. It's just one step indirect. It's so for instance, if you sell your home that's in this trust, you have to bring the purchase agreement to your trustee and say, sign this. When it comes time to close on the sale of your home, it's your named trustee that you have to drag into the closing ceremony to sign your warranty deed, transferring it to the buyer, and then you reverse that process for a purchase. Does that make sense? So it's more of a hassle, but you still retain control. So you got to be committed to understand that life is going to be more complicated as the cost for protecting those core assets. It's effective for most folks. The most valuable asset they own is their home, and it works really good for transferring real estate to your kids. You go into the nursing home, you'll never have to sell your home so long as it's been done far enough in advance of your application to pay for care. And that's more slides, and I'm a little afraid we might not get there, but we'll keep going. So I've got the slide that compares and contrasts the two trusts that we talked about. This is going to be available online, and I will also put this PowerPoint, I'll get it to the library so you can individually look at these slides if you access it online. So I'm not going to go into the great detail that you see here, but I have had arguments with folks. They say, if I have an irrevocable trust, I talked to a lawyer one time and I can't have any of these rights that you talk about. I have to give up total control. Once upon a time, the only reason people used to use irrevocable trusts was for the purpose of reducing the value of their assets, so there was less that had to be paid to the IRS for federal estate taxes. Those types of irrevocable trusts are horrible. Fortunately, you have to have a pretty good fortune to even have to worry about federal estate taxes. So nobody that I represent would ever have an interest in this. I think I maybe have 2 or 3 clients that would qualify, but because their estates are so large, I kick them to the boutique law firms that handle people with extremely high net worth assets, because there just isn't enough people that have estate tax issues to stay up on that area. But you would never want a traditional irrevocable trust. I would never recommend anything other than what I've talked about here. So it's partially irrevocable. You give up those rights while you're alive. The rest is flexible, and you can be a trust advisor bossing around the trustee. Any other questions before I move on from this area? It's been about an hour. If anybody needs to run to the restroom, get a drink of water quick, I don't want you to feel like you're prisoners here. This is kind of dry, and I get that. So if you need to stand up and stretch, you won't defend me. Does anybody want to take a break? Oh, I'm flattered, you guys. Okay, so one of the coolest things about trust is it allows you to be very creative in how you develop your plan regarding how and who gets your stuff after you die. If you can dream it, I can draft it. So what are some of the things that you can accomplish? First of all, can I tell you guys a little joke? All right. Ole and Lena. So Ole and Lena are sitting around the breakfast table, and Ole just has this brooding look on his face, and it's really starting to irritate Lena. So she said, "All right, Ole, what's the problem?" So I've been thinking, Lena, if I died and you remarried, would you let him drive my truck? She says, Ole, I'm not going to have this conversation with you. And about 10 more minutes goes by, and he's still just brooding, and Lena's getting frustrated. So she says, all right, Ole, what? Well, can't get off this topic. Will you let him sit in my easy chair? I mean, it's shaped to my hind end. Would you let him sit in it? She said, Ole, not going to talk to you about this. This is foolish. And half a day later, he's still just glowering, and Lena says, all right, that's it. You got to quit. He says, well, just one more question. Just one more question, and then I'll leave it alone, I promise. If I died and you remarried, would you let him use my golf clubs? She said, of course I wouldn't let him use your golf clubs. So wait a sec, you wouldn't even answer the question when I asked before. What makes this different than everything else? And she said, well, he's left-handed. So it's a fun little joke to illustrate a problem with planning with a will, which is that wills are individual, and there's no such thing as an agreement that is enforceable for my spouse and I to go make identical wills that are enforceable against that person if I die first. So really the only will that matters is the will of the second to die, and they can go in and change it, and there's nothing you can do about it. You had the bad fortune of being the first to die, and that's it. If I die and my wife remarries and she goes into the lawyer and changes that plan and gives everything to her new spouse at the expense of my kids, Biff the pool boy, he's a pretty nice guy. She wants to take care of him. If you use a living trust, it is possible to make a legal plan that is binding on both of you, regardless of the order in which you die, because you get to decide the point at which it becomes irrevocable or unchangeable. So you can structure it. It's very, very common for me to structure a trust plan so that it will say, when one spouse dies, the survivor will continue to have the power to make changes to keep a thumb over those kids, but they lose that power the moment they remarry or cohabitate with, move in with somebody with whom they're romantically involved. That immediately cuts off their ability to change the will that's built into the plan. Voila, you've got a plan that is binding on both spouses, regardless of the order that they die. And not that we're taking the checkbook away from the survivor, we just don't want them to redivert where it goes after death. Nothing prevents your spouse who survives you from building a new pot or a new wagon with a new spouse. More power to them, but this wagon's spoken for. Does that make sense? Us guys, we need to be reminded, the guys I know, the guys that are like me, I'm helpless without I can barely cook macaroni and cheese, and I'm very lucky my wife is an excellent cook. I know that if something happens to her, I'm probably going to need someone to take care of me. But I don't want something to happen, or my wife especially would not want me to get, my fingers wrapped around somebody that is, nothing but a smooth talker and only interested in my assets. And that's a pretty effective tool you can only get with a trust. One of the most common forms of planning that are often inserted into wills, with people not even realizing they're talking about trust, is protections for underage beneficiaries. Who here had a will that said everything goes to my kids, but they don't get it until they reach a certain age? Anybody have a will that says something like that? Ooh, I don't see any hands. Okay. This is one of the most important, in my opinion, most important parts of planning if you have grandchildren that are under an age where you deem them mature enough to manage their affairs. Because if the good Lord decides to take one of your children before you, you don't want to cut those kids, the grandkids, out of your plan, usually. So assuming that's the case, you need to create a framework where an underage beneficiary will have some training wheels on their share of that inheritance until they reach an age where they're mature enough. You're not saying they can't have it, you're just putting a gatekeeper in place, someone who can help them decide whether it's a good reason to write a check or not. And by the way, 18 is far too young. Never give a child money at 18. Man, I still remember how I viewed the world when I was 18. I thought my parents were dumb and I thought I knew everything. And if I had come into a pile of money, I'd have bought a four-wheeler and a stereo for my car that was more valuable than the car, and it would have been gone. So this is very important. Disabled heirs. There is a landmine buried in the law. Let's say the car accident that takes your child's life leaves a grandchild disabled. Traumatic brain injury or spinal injury or something like that. Now you have a grandchild that is living off of Social Security. The Social Security system is very generous in the sense that if you have no means to support yourself because you are disabled, the government will give you Social Security early. You can live off of it. However, if you haven't worked enough years in the Social Security system to fully vest, that is a means-based program. And if you receive an inheritance in that environment, you'll get kicked off your benefits until you burn through your inheritance, and then you can sign up again. I've seen that happen a few times, and it is heartbreaking. And it's really easy to plan around. You just simply say, all right, I give everything to my kids in equal shares. However, if I have a beneficiary that is drawing Social Security disability at the time of my death, that individual share gets held with the gatekeeper trustee, and it can be used on their behalf for anything Social Security doesn't provide. It's a little more complicated than what I just said, but not a lot. And now you've created a framework where a beneficiary who's drawing Social Security disability can fully enjoy their inheritance. They just have to do it through a gatekeeper that everybody trusts. Now you don't harm them. It's a really powerful tool. Creditor protections. I mentioned a couple times the spendthrift child. We had a family member over here who was maybe not well suited to manage his own share of the inheritance. Very common problem in families. I see it probably once a month or so. There's that one black sheep child. I strongly discourage folks from disinheriting children. Bear in mind, even if children have caused you a great deal of heartburn over the years, the very last communication you will have with them is what you put into your plan, because the plan will survive you. And the last message to them probably should not be, I didn't love you enough to give you anything. So in my experience, taking families through those plans, it's painful for everybody, including the lawyers involved. I really try to steer people away from that. But what we try to do is create a framework where someone who is not well suited to manage their share gets theirs in a framework where it's overseen properly. And that works pretty effectively. And getting back to the whole notion of disinheritance, you don't have to give everybody everything equally. What's equal isn't always fair. So I'm not telling you you have to treat all of your kids the same, but I strongly discourage disinheriting children. Divorce protections. I have had, this seems to be a farm family concern, farm family mothers. They're terrified that their child's spouse they'll receive their inheritance and the spouse will immediately divorce them and try to take, a chunk of the farm away. Whether that's rational or not is up for debate, but doesn't make it less of a concern for clients when they bring that up in my office. So what we're talking about there is creating a framework where whatever you want to pass on to the child, don't make the child pull everything out. They can leave their share in the wagon and have the wagon buy them what they want without pulling it out. They want a car, have the wagon buy their car. Their name isn't on it. Their creditor, their divorcing spouse can't get it. There's some really cool asset protection tricks and tips we can do using trusts. And this one's my favorite. If you care about something strongly or you want to encourage somebody to act a certain way, you can design your plan to promote these types of things. So let me give you an example. I had a client one time who had quite a bit of money, and he was kind of an absentee parent. He had gotten a divorce from the mother of his children a number of years prior and wasn't around a lot, but loved his kids very much and wanted to share his success with them after he died. But he was also very concerned about the work ethic these kids had generated and was afraid that if he died, those kids would just get a pile of money and they would never work an honest day's work ever again. So he said, how do I incentivize these kids to work for their inheritance without just being bumps in the log? And I said, what about this? What if we tell them they get from the trust an amount equal to what they made each tax year? So if you have one that just flips burgers for a year, their distribution from the trust is not going to be nearly as large as someone who gets a college education, goes on and pulls down a much larger annual salary, because they'll be amplifying what they can make in a given year based on how hard they work and how much they can earn. Be productive and it pays off. Of course, the value we're promoting there is hard work. Cutting your own way, and then it pays off. If you have a goal, I can promote it. Another one I actually see very commonly is farmland. How do we prevent the kids from just running out, selling it, turning it into cash, and buying their toys? I mean, the good Lord isn't making any more farmland. Very common concern. Well, a framework we'll often use to promote holding a land is, say, for a period of 5 years, the kids can't sell it. You got to hold it. They get the cash rent. They pay the taxes and insurance. They get to distribute that out to themselves. And they get to see how easy it is to draw passive income off of that land. And you do that for enough years, hopefully you hook the kids, and after that time frame runs, you tell them they can sell it if they all agree. But by that point, you're hoping they're good with it. Just let it be, because that money is like manna from heaven. It comes every year. It's the easiest money they'll make. Again, we're just trying to promote the benefits of holding the land. So the idea is, if there's something that concerns you, share it with your attorney, because your attorney might be able to help you create a plan that addresses that issue, that promotes that value. Creative plans can do an awful lot. All right. Who here wants to talk about taxes? Anybody? If you care about it, I'll keep talking about it. This is super boring. So he's nodding yes. Okay. It's already been an hour and 15 minutes. So the library closes at 8, and we can't stay longer than that. I'll just try to summarize for you, okay? So, I wish I had caffeine to give you. It's good news right now. The current climate is very generous in Washington, D.C. If you die with $1 billion right now, you give it to your spouse, there's no estate tax that needs to be paid. If you have more than $11,700,000, you'll have to pay federal estate tax unless you are married. Married couples get to double that, so you have to have over $22 million, actually over $23 million before you have a taxable estate. So I'm sorry if I offend you because I don't know how much any of you are worth here, but I'm willing to bet a lot of money there's probably nobody in this room that has to worry about federal estate taxes. And if I'm wrong, see an attorney because you got a planning problem. Who here is from Nebraska? Anybody? Okay, we got a couple. In Nebraska, there is inheritance tax, state level inheritance tax. Spouses, again, have an unlimited exemption. If you're giving to your lineal descendants or ascendants or siblings, the first $40,000 given to each recipient is disregarded. Everything over that is taxed at 1%. So it's not a terrible tax, but it certainly is annoying to the family, trust me. 2023, though, based on new changes in the law, that actually goes, the amount you can pass exempt goes up to 100. So each recipient gets to exempt the first 100,000. But again, everything over that 100,000 per recipient is taxed at 1%. So if you are terminally ill and you own property in Nebraska, just hang on till after the first of the year. If you are allowing an inheritance to pass to aunts, uncles, nieces, nephews, their descendants, and their spouses, right now, the first 15,000 per individual is exempt, and the rest is taxed at 13%. So it's an incentive to be greedy and keep it within your tight, family. After 2020 or beginning January 1, 2023, that jumps up to 40,000, which is a nice boost, and they reduced the tax rate from 13% down to 11. So that's not that much better, but it is marginally better. Everyone else that's not on that prior list, only as of right now, the first 10,000 is exempt. After January 23, it jumps up to 25. Right now, everything is taxed at 18%, and after the first of the year, it'll be taxed at 15%. So long and short of it is keep it in the family. Does anybody here own property in Iowa? Any Iowa landholders? All right, we can skip the slide. This is an entirely separate conversation that will probably take another hour. So if you guys want to talk about the nursing home, when I do initial estate planning consultations, initial consultation is free. It's an opportunity to ask me anything. I can go through all of this with you. So feel free to call my office to schedule an appointment. I'm really sorry because I know this is something a lot of people are interested in. It's usually one of those areas I get the most questions about.
You have some contact info so you can leave out individuals.
That bag that I have, I think I had some in the bag. Yeah, I'll just have to run out and grab them. I think I've got some cards. Yes.
Are you able to come back and do another talk on just that?
Sure. As long as they'll have me. I was invited to come here, so I have to be invited back. But yes, this is important, and this concerns a lot of folks.
Show of hands, how many people want that?
Yeah, goodness, yeah. I'm sorry. I never know how much time to focus on every slide, but this PowerPoint presentation will be available, and there's quite a few slides that go into the details about this, but having the context of the explanation will probably be very helpful too. And I am happy to share this with all of you, either at another future presentation or an individual appointment. So I apologize that I've run out of time. Unfortunately, the city has to pay overtime if we all hang out, and I don't know that they've been authorized to do that, so.
I just had a quick question.
Yeah.
I got a question in a couple of weeks. How much stuff do I have to have figured out ahead of time, written down before I come to see you?
None. All right, so my typical planning works like this. The first meeting is educational. Opportunity to learn as much as possible, ask as many questions as you can, and you're not going to get a bill. It's the best kind of meeting with a lawyer. If you want to do some planning with me after that, the next meeting would be the appointment where you tell me what type of plan you think fits you best and we map it. And then the one after that, we review and sign it, assuming I nailed it on the first try. And then after that, I give you your binder to take with you and you're done. So, so it takes a few meetings, but the first one's totally free, so there's no risk in scheduling it and coming in to talk.